We'll hear argument next in Case 17-1678, Hernandez versus Mesa. Mr. Vladeck.
Mr. Chief Justice, may it please the Court. When this case was first argued to this Court 2 years ago, counsel for Respondent and counsel for the United States were both asked whether petitioners would have a Bivens remedy if Sergio Hernandez had been standing on U.S. soil when he was shot and killed by Respondent. Both said yes. The question before this Court today is therefore whether a Bivens action is nevertheless foreclosed because in this case Sergio was standing a few feet to the Mexican side of the border at the time he was shot. For two reasons we believe that it isn't. First, the fortuity of where a victim is standing does not in fact trigger any of the special factors counsel and hesitation identified by Respondent or the United States. Most importantly, it is difficult to see how foreign relations could be a special factor precluding a Bivens suit here if it wouldn't have precluded a Bivens claim had Sergio been standing just a few feet away. Moreover, the government's assertion that permitting petitioner's suit would dramatically undermine U.S. foreign relations and diplomacy is belied by the long history of successful tort claims against federal law enforcement officers, including, as in the Apollon, cases in which the victim was a foreigner harmed on foreign soil, the court awarded damages, and the diplomatic sky did not fall. Nor does extraterritoriality cut against a Bivens remedy here. Not only was Respondent standing on U.S. soil when he pulled the trigger, but he could not have known in that instant where the bullet would even land, let alone the nationality of anyone it might hit. Second, and as importantly, for petitioners here it is Bivens or nothing. Neither Respondent nor the United States seriously disputes that the Westfall Act preempts the Texas tort remedy petitioners could otherwise have pursued, and neither has identified any other alternative remedy for the petitioners here as opposed to other parties in other cases. All of this goes to why this Court was right in Abbasi when it explained that there are powerful reasons to retain Bivens as a remedy for individual instances of law enforcement overreach, and it goes to why, even though Sergio was standing on Mexican soil when he was shot and killed, this case presents the exact kind of law enforcement overreach that Abbasi had in mind. I think Abbasi is a useful place to begin our analysis because in that case, not only did this Court suggest that there were still important reasons to retain Bivens in law enforcement contexts, but this Court itself actually preserved and retained one of the plaintiff's Bivens claims. This Court returned to the district court rather than dismissing the prisoner abuse claim against the warden of the MDC. And we think that reflects four of the reasons why retaining Bivens in the law enforcement sphere makes sense. First, as this Court said in Abbasi, it is difficult to contemplate other remedies when individual instances of law enforcement overreach are at play. In those contexts, a damages action after the fact will usually be the only possible legal recourse. It's going to be difficult to bring a claim in advance. Second, the deterrence effect, what this Court has called the core purpose of Bivens, which is to deter individual officers, could quite easily be lost in the absence of remedies in the law enforcement context, unlike in Abbasi, where, as this Court stressed, there were alternative remedies available to the plaintiffs. Third, the historical tradition that we note in our brief, where federal courts and state courts, going all the way back to the founding, routinely imposed tort damages against federal officers acting ultra vires without suggesting there were separation of powers obstacles to doing so, without suggesting that there was anything wrong with the federal courts providing a cause of action in those cases, as opposed to, I think, where the inquiry historically has focused, immunity. Are there reasons in these cases to actually hold the defendant officer harmless, not because there's no cause of action, but because he was acting in good faith or under the modern standard because he did not violate clearly established rights of which a reasonable officer in his position would have been aware?
They argue.
If the officer in this case had been a state officer and everything else was the same, would the victim have a claim in federal court?
If the question's in federal court, Justice Alito, I think it would depend on diversity. I don't believe the victim would be able to bring a claim under 1983 because, as the government points out, the language of that statute limits the class of plaintiffs to U.S. citizens and those subject to the jurisdiction thereof. But, Justice Alito, Congress, when it enacted 1983, as Judge Prado noted in his dissent below, was not thinking about limiting remedies that were otherwise available. It was thinking about expanding remedies in that context in 1871 to newly freed slaves. So 1983 does nothing to displace whatever state tort remedies might be available against state officers. Now, of course, that's going to vary a bit.
Suppose there were no 1983, and a state officer had done exactly what the Bureau of Narcotics agents did in Bivens. Would there be an action against the state officer?
There would be, Justice Ginsburg, and actually I think it's worth in this context reminding the Court of the government's position in Bivens. The government's position in Bivens itself was not that the federal courts should not be recognizing these remedies in any context. Rather, the government's position in Bivens was that New York state tort law would have provided an adequate remedy, Justice Ginsburg, not just against the federal officer defendants in Bivens, but also had they been, say, New York City police officers. That New York trespass law would have provided the remedy. To quote from the government's brief in Bivens, a federal remedy should only be recognized when it is necessary. And the argument in Bivens was simply as to whether a complementary federal remedy was necessary to vindicate the plaintiff's Fourth Amendment rights, given the existence of New York trespass law, given the government's argument that New York trespass law in that context was adequate to vindicate the plaintiff's Fourth Amendment interests. And this was the common law model. I mean, I think we are all familiar with Henry Hart's dialectic, where Professor Hart suggested that the original understanding was that even federal officers would be principally responsible to judges in state court. There was no general federal question statute.
You referenced the government's position in Bivens. That was almost 50 years ago. In the interim, there's been a fairly dramatic change in how we approach things as implying causes of action, both under statutes and under Bivens. I mean, it's been, 40 years, right, since the last time we recognized a cause of action in Bivens? So I think you need to sort of move up half a century and explain to us why we should take your approach today, regardless of what the prevailing legal regime was in 71.
I take the point, Mr. Chief Justice, and if I may offer 2 points in response. The first is I say all of this by way of putting Bivens in context. That is to say that rather than a bolt from the blue, Bivens was a continuation of this tradition. But to wind the clock forward, which I think is, of course, the task for the Court today, I think it's worth stressing that of the 9 cases this Court has decided since Carlson, which the government points out at page 11 of its amicus brief, where this Court has had the opportunity to recognize a Bivens remedy and has chosen not to do so, none of those involved a claim that an individual federal law enforcement officer was acting ultra vires. None of the suits involved the kind of claim we have here. None of the suits involved the context in which this historical tradition was at its richest, Mr. Chief Justice. None of the suits, or at least not all of the cases, even involved claims that would have had a common law parallel. And so we certainly recognize that this Court has been increasingly skeptical of judge-made causes of action in general and of Bivens in particular. Our point is simply that skepticism has been reserved, or at least focused, on categories unlike this one.
If Bivens were a statute, in effect, we would apply the presumption against extraterritorial application, and the other side argues that therefore, even if it were a statute, it wouldn't apply in a circumstance like this. What's your answer to that?
Well, I think we have 2 answers, Justice Kavanaugh. And I think the first and most important is that, but Bivens is not a statute. And that this Court has never suggested, for example, that in looking at whether particular constitutional provisions apply extraterritorially, we would use any of the typical presumptions that we apply to statutes, because it is a fundamentally different task from the perspective of looking at the extent to which the Constitution applies overseas versus what Congress would have intended. But even if this Court nevertheless believes that it's appropriate to map on that presumption, I actually think Kiobel helps us more than it hurts us, because in Kiobel, this Court said there will still be cases in which the underlying conduct, the gravamen of the plaintiff's complaint, involves activity that touches and concerns U.S. soil with sufficient force to displace the presumption against extraterritoriality. And so I think this Court could assume without deciding that extraterritoriality is a special factor for purposes of Bivens and still say this case is different because respondent was standing on U.S. soil at the time he pulled the trigger. That is touching and concerning U.S. territory, from my perspective, the way Kiobel meant it.
What would distinguish?
But the victim, Hernandez, this Court has said, I think, that a non-citizen who's injured abroad doesn't have any Fourth Amendment rights. So what is this? It seems like a rather arid discussion if at the end of the day there is no federal constitutional right that can be asserted by a non-citizen who is injured abroad.
So I think, Justice Ginsburg, that Verdugo certainly stands for the proposition that in that case there was no Fourth Amendment protection for a Mexican national whose home was searched by DEA agents operating in conjunction with the Mexican government. I think this Court itself suggested in Hernandez 1 2 years ago that the Fourth Amendment question in the context of a cross-border shooting is more complicated. And it is the fact that that question is unsettled. That is,
this is my question, too. I want to pick up on Justice Ginsburg. What then is the limiting principle? We have a foreign national injured abroad by an action in the United States. I can think of a lot of cases that that's going to encompass, right? Not just cross-border shootings, but all kinds of torts that can occur transnationally. Would you capture all of those?
Not at all, Justice Gorsuch. And as I hope was clear,
it can't be that this is good for one shooting only, right?
No, and first, I think this Court is well aware that there's been more than one shooting.
I understand that.
But no, I think the larger point is our position focuses on the law enforcement nature of the conduct at issue here. And so many of the hypotheticals that I suspect you are thinking of, Your Honor, and that I'd be thinking of for context in which a U.S. Government person in the United States could...
Why would it be limited to law enforcement as opposed to other governmental functions that happen here but happen to injure persons abroad?
Because I think it's in the law enforcement context that there is the strongest argument, the strongest appeal to the historical tradition we note in our briefs, where there is a straight line dating all the way back to the founding, where it was law enforcement, where common law remedies against federal officers were so important. There aren't many examples, I could find none, of combat operations, for example, where state courts were imposing tort remedies against federal officers.
So you'd have you draw a line there actively in this case and say that any actions involving military operations, diplomatic operations, any other operations of government are not, there's no Bivens action there. It's only for law enforcement, whatever that means, operations.
So, obviously I wouldn't decide more than is necessary, but I do think...
Okay. But that's what I thought you'd say.
But
all right? And so where is, if you're not willing to draw that line, where is it? And how is this Court supposed to draw it? You say you could say this, but I wouldn't say it. All right? Where would you draw the line?
I think based on this Court's jurisprudence and based on Abbasi itself, I think the line could reasonably, plausibly...
No, not reasonably, plausibly. Where would you have this Court draw the line?
Well, I think, frankly, there are decisions this Court has handed down in the Bivens context that I think aren't necessarily consistent with this full tradition, but it has still left open law enforcement conduct, Justice Gorsuch. And it's not just this Court that has done that. Congress, in the 1974 amendment to the Federal Tort Claims Act, went out of its way to expand the liability of the United States for intentional torts committed by law enforcement officers.
Well, it's not just intentional torts, it's rogue intentional torts. That's an important limiting principle.
It absolutely is, Justice Sotomayor, and I hope it's clear in our briefs.
Accepting the facts of this case, the use of forces on U.S. lands, and it's unreasonable because the claim is that this young man was doing nothing but standing on the other side of the border.
And I think this might be a sort of a more convincing answer, I hope, to Justice Gorsuch, which is I do believe that it is relevant to the claim and the strength of our claim in this case that the respondent was, according to the plausible allegations in the plaintiff's complaint, violating not just the Constitution, but his own departmental regulations, that we have not just a law enforcement officer, Justice Gorsuch, but a law enforcement officer acting ultra vires.
But is they really supposed to decide this? I mean, I thought — I wrote a dissent, I guess, but I thought this is special because it's American law enforcement, American soil, and he thought he might be shooting at an American. And the border in this case is rather special. It's not just the line, it was the river, and it's administered by an international commission, Okay, I have about 6 wonderful reasons that persuaded only me. Okay.
I believe you also persuaded one.
I thought we're taking this case on the assumption that the Fourth Amendment does apply. And the only issue in front of us is not that, but rather we assume that the Fourth Amendment applied, that it is a clear violation of the Fourth Amendment, and the question is Abbasi, whether there is a Bivens action for a clear rogue violation of the Fourth Amendment that takes place in the way this does. Is that sufficient, to use the Abbasi term that which I've now lost, but the Abbasi term that this is some kind of extension of the Fourth Amendment, or that this is some kind of special situation? That, I thought, was the issue. And at some point, I feel I'll try to answer that question, but I'd like to hear what you say about that.
I agree completely, Justice Breyer. I mean, I think that Abbasi – I don't think Abbasi –
I don't care whether you agree or not. All I want to hear is your argument on – I don't want to repeat myself, but on the assumptions I gave, yes. What is your argument that this is not an extension, that this is not special, that this is not an unusual thing? What's your argument?
So our argument is, first, that this Court has long recognized that claims against individual law enforcement officers for excessive force are what the Fifth Circuit called classic Bivens claims. I believe there's an opinion by then-Judge Kavanaugh referring to it as the core of Bivens, to bring a claim that an individual law enforcement officer was acting ultra vires. So, Justice Breyer, I think there's at least an argument that this might not even be a new context. But even if it is a new context, the government and respondent have identified three special factors that they argue counsel hesitation. First, they say it's because this case implicates foreign relations and national security. As we suggest in our briefs, we don't believe that follows simply from the fact that Sergio Hernandez was standing on the Mexican side of the border as opposed to the American side of the border. The government also argues extraterritoriality is a special factor. As I hope I explained in response to Justice Kavanaugh's question, we don't think extraterritoriality is implicated here because this case touches and concerns U.S. territory with sufficient force to displace the presumption. And the third special factor invoked by respondent and the government is congressional action. And I think in that context, there's no example of Congress specifically trying to preclude claims like petitioners here. And the only time Congress has ever spoken to the tort liability of, again, Justice Gorsuch, this is where we get our test from, individual federal law enforcement officers. Congress has expanded that liability.
Counsel, just to go with the first of the things you mentioned, the international relations, there has been diplomatic correspondence between the Mexican government and our government with respect to this incident. The Border Patrol has conducted an investigation, and it reached the determination that the action of the agent was not contrary to policy. And you would have the courts look into this by providing a Bivens remedy that could well come to the opposite conclusion, so that in terms of our relations with Mexico, we'd have one agency saying this was not inconsistent with policy. We'd have the court saying it is. And that is the type of thing that it makes it at least a new context. You can say it doesn't make a difference. But in terms of our relations with Mexico, they've got two different things. And at least with respect to foreign relations, I thought the country was supposed to speak with one voice.
So I certainly agree that the country is supposed to speak with one voice, Mr. Chief Justice. Two points in response. The first is, of course, if the government continues to believe and if respondent continues to believe there would be a Bivens remedy if Sergio Hernandez had simply been standing on American soil, it's not clear to me why the same concerns wouldn't be equally present. That is to say, by that logic, any time a U.S. officer harms any foreign national, even if Bivens itself, if Bivens had been a foreign national, it's not hard to imagine similar diplomatic correspondence following from that incident.
They argue it's not merely the foreign policy implications that the Chief Justice identified, but that border security is also national security in some respects, and that's a different context, slightly different than the foreign relations. Can you address that?
Absolutely. And we certainly agree that border security as a policy is an important policy of the United States, that if we were here challenging one of the government's border patrol policies, this would be a different case. But I think it's important to note, back to the Chief Justice's question, that the dispute here is over whether respondent violated the very government policy at issue. That is to say, we are not challenging a policy of the government. We are claiming respondent himself did not comply with that policy. The government's entitled, Mr. Chief Justice, to its own preliminary determination of that question. We don't think it is the kind of policy to which this Court has historically accorded deference in the foreign relations and national security sphere if it's an after-the-fact factual determination about a single incident, as opposed to, say, a challenge to an entire Border Patrol policy.
I thought you were challenging the constitutionality of what was done, not whether it was consistent with Border Patrol policy.
So, Justice Alito,
does that provide the basis for a federal claim? If you put the Fourth Amendment aside, but the action was contrary to Border Patrol policy, would that provide the basis for a federal claim?
Not for a damages suit, of course, but
yes.
But it is our position, Justice Alito, that just to go back to my colloquy with Justice Gorsuch, again, the reason why we believe this is in the heartland of Bivens, notwithstanding the concerns that the Chief Justice has referred to and that Justice Kavanaugh alluded to, is because here we do not have a case where the claim is that a particular policy of the United States in the foreign relations or national security sphere was the source of the injury to the plaintiffs. Here our argument is that the policy is actually coextensive with the Constitution, and so that if we are correct, which we have not yet, of course, had a chance to prove, but if we are correct that respondent violated petitioner's Sergio Hernandez's constitutional rights, Justice Alito, then it would also be a violation of policy. And so to us, the questions blend together because it helps to drive home why this case is not like the 9 cases this Court has had since Carlson.
Can we go back to the question that I asked? If breaking into someone's home and searching and seizing, if that's not a Fourth Amendment violation because the person is a non-citizen and it happened abroad, you said a cross-border shooting is more complicated. Why should it be different?
So, Justice Ginsburg, with respect, I actually think it was this Court that said that in Hernandez 1, and I think the reason why is because there is some uncertainty in the lower courts, as reflected in the Ninth Circuit's decision in the Rodriguez case, the original 3-judge panel decision in this case. There's some uncertainty about just how broadly this Court's decision in Verdugo or Quides, in which the Court said a Mexican national could not invoke the Fourth Amendment to challenge the search of his home, the warrantless search of his home by a DA officer. There's uncertainty about how far that sweeps. Is that a categorical on-off switch at the border? Or are there reasons to actually think the Fourth Amendment question is more complicated in the context in which you have cross-border episodes, especially after Boumediene? That is to say, does Verdugo still have the same force? Now,
Mr. Vladeck, there is one part of the Chief's question you didn't answer. The government speaking with one voice, and you said the government should. But he's posited a big difference here. The executive has said this was not a rogue action. This security guard, they've concluded based on what we don't know, that this officer was being attacked, and that's why he shot. The allegations of this complaint are to the contrary. If the court were to rule in favor of your client, not the court, but a jury were to found in favor of your client, wouldn't we be speaking in two voices? You haven't addressed that.
Thank you, Justice Sotomayor. And I think our response is I think that this Court has never suggested that every single thing the United States says that has any bearing on any possible sliver of foreign relations is the kind of foreign policy where this Court has said the government should be allowed to speak with one voice. And so I think there's a meaningful distinction between a policy that is ex ante shaping the conduct of our Border Patrol officers, of our government officers, where a judicial decision might call into question the policy, and a context where the dispute rises and falls on whether the government's own policy prohibiting excessive force in violation of the Constitution was violated. That is to say, it seems to me that there's merger.
Well, what if, Mr. Vladeck, you have this one incident and the executive branch had a very different view of what happened than a court did? A court said there was unconstitutional conduct here, the use of excessive force, but the executive branch thought he did everything by the book, and he shouldn't be subject to any action, even a disciplinary one. And then the court's decision contrary to that, let's say Mexico wants to extradite the Border Patrol officer. And that puts, I would think, the executive branch in a quite difficult situation. Mexico is pointing at a court judgment, but the executive branch thinks that there's no earthly reason to extradite. What happens then?
Well, I think, Justice Kagan, there's a critical difference between what the preclusive effect of a civil judgment about the unconstitutional conduct by the officer would prove, and whether the Mexican government would be able to satisfy the very different inquiry of whether there's sufficient evidence to sustain a criminal indictment and to warrant extradition under the terms of the U.S.-Mexico extradition treaty. And I think that's the key point here, is that on the government's logic, all it takes is the government showing up after an incident and saying, oh, there's some reason why we don't believe this was unlawful, or there's some foreign relations implication to a judgment holding it's lawful. And if it's after the fact, that won't matter. It would still preclude Bivens.
Well, that's, I think, a fairly unfair characterization of what the government did in this case. According to their representations, it was a fairly thorough investigation. And maybe it's at the end of the day, maybe a jury would come to a different determination than the governmental investigation, but I don't think that's fully responsive to the international relations concerns.
That's
or even if not fully responsive, it has to be demonstrated. It's simply a new context for the Bivens question.
That may well be, and I think our submission is simply that the question this Court has always suggested in the Bivens context is how to preserve its core deterrent purpose. And in a context in which the government's after-the-fact factual determination that an officer had acted appropriately under the circumstances were sufficient to be a policy choice that does not actually give rise to the kind of deference this Court has historically accorded. Right? That's what we're worried about, because it's not clear how that wouldn't potentially, if not in this case, swallow the category. Right? That is to say, if a bossy meant what it said, when it said there are powerful reasons to retain Bivens in the law enforcement context, we think that's true, Mr. Chief Justice, even when the government has other equities at stake. Because, again, the key for us is when a court is saying an individual officer has acted ultra vires, it is not the same thing as saying the government's policy is somehow inconsistent with the Constitution. It's not the same thing as saying we are second-guessing how the government has chosen to conduct Border Patrol policies. It's simply